Welcome back to the Deep Dive. Today, we are tackling a legal doctrine that, it hits incredibly close to home, literally.
It really
It
does.
sits right at this really uncomfortable intersection between a child's right to be safe and, a parent's right to raise their family without the government or a jury second-guessing every little decision. We're looking at that tension. The child's right to recover damages versus the state's desire to, preserve family autonomy. And we're going to explore this through a scenario that is just visceral. A 17-year-old boy, a backyard trash fire, an exploding aerosol can.
And a lawsuit filed against his own father.
Exactly.
It is a heavy set of facts, but it perfectly illustrates the legal problem we need to solve today. So to navigate this, we're going to follow a very specific path.
Okay.
First, we need to establish the status of parental immunity in Michigan. Then second, we'll dissect the reasonable parental authority exception.
The key exception here.
The key one. Third, a rigorous FIRAC analysis of a case called Neely versus Sewell to see how the court treats claims of negligent supervision. And then finally, we'll pull it all together into a diagnostic checklist you can use for an exam.
I love a good checklist.
Yeah.
So let's start with the basics. In Michigan, what is the general rule regarding a child's ability to sue their parent for just, ordinary negligence? If a parent makes a mistake and their kid gets hurt, can the kid sue?
To answer that, you have to look at the seminal case, which is Plumlee versus Klein from 1972.
Okay.
The general rule from Plumlee is that the Michigan Supreme Court largely abrogated common law parental immunity.
So abrogated. They basically got rid of the old rule.
That's right. As a baseline, a child can generally sue a parent for injuries from ordinary negligence. The old idea that you absolutely can't sue your parents is, for the most part, gone.
So the door's open. But I'm guessing, since we're doing a deep dive, that the door isn't wide open. What's the catch?
Precisely. Plumlee retained two very specific exceptions where immunity still applies. Situations where the parent is shielded from liability.
Okay, give us the black letter definition. What are those two exceptions?
Here are the Plumlee exceptions. Exception number 1. Immunity applies where the alleged negligent act involves an exercise of reasonable parental authority over the child.
Okay, authority.
And exception number 2. Immunity applies where the act involves an exercise of reasonable parental discretion over providing necessities, so food, clothing, housing, medical, and dental services.
Right, so authority and necessities. Today, our focus is squarely on that first, one reasonable parental authority. And to test its scope, we're looking at Neely versus Sewell from 2011.
That's the one.
Let's analyze Neely. First, what are the legally dispositive facts?
The facts are, they're straightforward but tragic. On March 8, 2009, the plaintiff, Brandon Neely, who was 17 at the time, was helping clean his step-grandmother's house. To get rid of garbage, they started a fire in the backyard. Brandon was adding trash to this fire when a bag with an aerosol can inside just exploded.
And the injuries were significant.
Yes, he suffered severe burns. And here's the crucial detail for the lawsuit. At the time of the explosion, his father, the defendant David Evans, was inside the house.
He wasn't even out there.
No. The plaintiff and his aunt were the ones outside. So the son, Brandon, sued his father for negligent supervision.
And what did that claim allege specifically?
It alleged that his father failed to set up safety standards and failed to warn or instruct him on how to safely dispose of hazardous materials.
So the son is suing the father for not watching him closely enough or, teaching him better. And what was the core legal issue?
The legal question is this. Does a parent's alleged failure to supervise, warn, or instruct a minor child about a dangerous activity, here, burning trash, does that fall within the exercise of reasonable parental authority exception?
And if it does?
If it does, the parent is shielded from liability. He's immune.
So what rule of law did the court apply here? Can you state the full black letter rule and break it down into its testable elements for us?
Absolutely. The court applied that first exception from Plumlee v. Klein. The rule is, a parent is immune from a lawsuit if the act involves an exercise of reasonable parental authority.
Okay.
And this breaks down into two distinct elements. Element 1, the conduct must be an act of authority. This covers things like supervision, instruction, or discipline.
Right.
Element 2, the authority exercised must be reasonable, but, and this is critical, the court interprets reasonable very broadly. It refers to the scope of the authority, not the quality of the act itself.
That feels like a really important distinction. Okay, thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the definition of parental authority?
Okay, so this requires a little mini IRAC on what authority even is. The sub-issue here is, does parental authority even include something like negligent supervision?
Is that authority or is it just carelessness?
Exactly. And the sub-rule, which comes from Michigan precedents, cases like Page, McAllister, Wright, is a clear yes. The courts have established that parental authority extends way beyond just discipline. It includes providing instruction, education, and, crucially for this case, supervision of the child's behavior.
So how do they apply that to the father, David Evans?
Well, the court found that what he allegedly did wrong, failing to watch over, warn, and instruct his son about the fire, was, at its core, an exercise of parental authority.
Even though he did it badly or not at all?
Right. The dangerous instrumentality was the fire. The father's decision on how to supervise his son around that fire was seen as a management of family affairs. So the conclusion on element 1 was clear, the element was met. The claim legally involves parental authority.
You mentioned the court relied heavily on precedent. Let's dig into that as, say, the second part of their reasoning. Consistency with older cases. How did they apply the facts of Page v. Bean construction and McAllister v. Sun Valley Pools?
Let's do a quick mini IRAC on those precedents. First, the sub-rule from Page. In that case, a child fell into a man-made hole. The court held that parental authority includes the responsibility to supervise a child to make them aware of dangers.
Okay.
Second, the sub-rule from McAllister. A 15-year-old was paralyzed in a family pool. The court held that managing family affairs, like teaching a kid how to use the family pool, is an exercise of supervision and therefore authority.
So how does that connect to a trash fire? What's the application to Neil?
The court said Neil is perfectly analogous. Just like parents decide how to supervise a kid around a hole or a swimming pool, the father in Neil decided how to supervise around a fire. The dangerous thing changes, but the nature of the parent's job supervision stays the same.
And after analyzing all the elements in the precedents, what was the court's final conclusion?
The court granted summary judgment for the father. Because the claim was for negligent supervision, it fell squarely within the parental authority exception, and that makes the father immune from liability as a matter of law. The case was over.
This brings us to a really difficult part of this whole doctrine. To truly understand just how broad this rule is, we have to look at the visceral fact patterns of the other cases the Neil court cited. I mean, it's one thing to talk about authority in the abstract.
It's another thing to see what that word actually protects.
Exactly. So describe the facts of Mickle v. Wilson and Wright v. Wright for us. Let's see just how high the bar for liability actually is.
These are the cases that really test your comfort with the doctrine. Let's start with the drowning scenario from Mickle v. Wilson, a 2010 case.
Okay.
A father takes his 3-year-old daughter to a party at a lake. He knows she can't swim. He leaves her to go to the bathroom without asking anyone specifically to watch her. And while he's gone, she drowns.
Wow. I mean, that sounds like textbook negligence.
It certainly sounds like it on its face. But the legal result, immunity applies.
How?
The court held that the decision to leave the child unattended, even if it was clearly tragically negligent, is a failure to supervise. And since supervision is an exercise of parental authority, the father cannot be sued.
That is incredibly stark. What about the Wright case?
This is the gunshot scenario from 1984. A father takes his child on a fishing trip. He's negligently overseeing her, and she accidentally shoots herself in the foot.
And the result?
Same result. Immunity applies. Negligence and oversight is protected under that big umbrella of parental authority.
These gross examples, as you call them, really confirm why the Neil court felt it had to dismiss the trash fire case. If a father is immune when a child drowns because he wasn't supervising, he's definitely immune when a child is burned because he wasn't supervising.
Exactly. The logic holds that if the court starts policing how a parent watches a child near a fire, then they also have to police how they watch them near a lake or a pool or a toolbox. The exception was designed to stop the courts from becoming this sort of super parent that critiques every family decision.
Okay, so we've got the general rule, the exception, the case applying it. Now, let's make this really usable for our listeners who might be staring down an exam question on this. Can you synthesize all these rules from Neil and Plumlee into a step-by-step diagnostic checklist?
Absolutely. Here is your 5-step framework for issue spotting on an exam.
Okay, step 1.
Step 1, identify the parties. Is the plaintiff a minor child and the defendant their parent? If yes, you're in this world.
Simple enough.
Step 2. Apply the general rule from Plumlee. You have to start with the presumption that immunity is gone. The child can sue. Don't jump straight to immunity. Start with liability.
Okay, so start with the door being open, then step 3.
Step 3. Test the exceptions. This is the immunity defense. You ask 2 questions. A, does the negligent act involve the exercise of reasonable parental authority? Look for keywords: supervision, instruction, discipline. And B, does the act involve discretion over necessities? Keywords: food, clothing, housing, medical care.
And step 4.
Step 4, this is the supervision trap. This is the big one. If the facts allege negligent supervision, failure to warn, or failure to instruct, you must immediately categorize this under Exception A, authority. Do not get distracted by how bad the supervision was. If the claim is about supervision, it's about authority.
That supervision trap seems to be where most people would get tripped up. You think if the supervision is bad enough, it stops being authority.
That's the mistake everyone makes. And that brings us to Step 5, conclusion. If the act falls into Step 3A or B, the parent is immune. Summary judgment for the defendant. If not, say, for example, it's reckless driving that has nothing to do with supervision, then the suit can proceed.
So really the policy takeaway here is that while the law says it allows suits for ordinary negligence, that definition of parental authority is so broad that it effectively blocks almost all suits related to how a parent actually watches their child.
That's it. Whether it's around a pool, a lake, or a backyard fire, the court basically views the how of parenting as a no-fly zone for liability.
So under Michigan law, authority includes the discretion to supervise negligently.
That is the hard truth of the doctrine.
A fascinating, if somewhat unsettling, look at the limits of the law inside the family. That wraps up our analysis of Neely v. Sewell. Keep that checklist handy and watch out for that supervision trap. We'll see you in the next deep dive.